I stood at the edge of my property, staring at what used to be my family's historic bridge. Splintered wood, twisted metal, and deep gouges in the creek bed were all that remained. The protected waterway now ran brown with disturbed sediment. Three men in matching polo shirts stood on the opposite bank, arms crossed, watching me. I gripped the court order in my hand so tightly it crumpled. 20 years as a federal judge had taught me to maintain composure in the face of injustice, but this was different. This was personal. They had demolished a protected historical structure while I was away, and they had done it with forged permits and falsified documents. The leader of the group stepped forward with a smirk. "Your property is now in violation of our community standards," he stated flatly. "We expect full compliance moving forward." That was the moment I decided this homeowners association was about to learn a very painful lesson about the law they thought they could ignore. I have always kept my professional and personal lives strictly separated. In the courtroom, I am addressed as Your Honor while presiding over federal cases that often make national headlines. But the moment I turn onto the gravel road leading to my ranch, I become simply a caretaker of land that has been in my family for 4 generations. I purposely live modestly on this rural property, finding peace among the ancient oak trees and rolling pastures that have weathered more than a century of changing seasons. The ranch house itself is not impressive by modern standards. Built in 1903, it features the same wraparound porch where my grandfather used to shell peas and tell stories about the Great Depression. What makes this property special is not its luxury, but its history and the painstaking restoration work I have dedicated my weekends to for the past 15 years. I have carefully preserved the original hardwood floors, restored the hand-carved banister on the main staircase, and maintained the stone fireplace where my family has gathered during winter nights for over a century. The crown jewel of the property, however, was the bridge. Constructed in 1924 from locally harvested oak and reinforced with hand-forged metalwork from the town blacksmith, it spanned Willow Creek, a protected waterway that winds through the back acres of the property. The bridge was not merely a functional crossing, but a historical landmark that had been granted protected status by both county historical preservation offices and state environmental agencies due to its unique construction and location over a sensitive watershed. I first noticed the changes to the surrounding area 3 years ago. A large tract of unused farmland that bordered the eastern edge of my property was sold to a development company. I had no objections to progress, and the zoning boards had approved the construction of a new subdivision. I even attended the community planning meeting, where they presented architectural renderings of modest family homes surrounded by preserved green spaces. It seemed reasonable enough. The first letter arrived 6 months after families began moving into the new development. It was printed on heavy cream stationery with an embossed logo reading, "Willow Creek Estates Homeowners Association." I remember standing at my kitchen counter, coffee in hand, somewhat puzzled as I opened the envelope. The letter was politely worded but contained a surprising claim that my property fell within their jurisdiction due to an easement agreement and historical property boundaries. "Dear resident," it began, "we are writing to inform you that our records indicate your property falls within the boundaries of Willow Creek Estates Community Association. We have noted several unauthorized structures that do not comply with community guidelines, including an unpermitted bridge structure over protected waterways." I actually laughed out loud. The bridge predated their development by nearly a century. Moreover, my property line was clearly documented and recorded with the county. I set the letter aside, assuming it was a simple administrative error made by overzealous community managers who were unaware of local history or property records. 2 weeks later, a second letter arrived, this one with a more formal tone and a list of violations that included the unauthorized bridge structure, as well as my split rail fencing, the historic barn that had weathered 100 seasons, and even the native landscaping I had carefully cultivated to protect the local watershed. Each violation included a corresponding fine that would be assessed monthly until compliance is achieved. I decided it was time to address this misunderstanding directly. I called the contact number listed on the letterhead and requested a meeting with the association representatives. The woman who answered seemed surprised by my calm demeanor, but agreed to schedule a discussion at their office the following week. I did not mention my profession. Years on the bench had taught me that people behave differently when they know they are speaking to a judge, and I wanted to observe how this association conducted itself without the influence of my title. The Willow Creek Estates Community Center was a newly constructed building with floor-to-ceiling windows and modern architectural lines that stood in stark contrast to the surrounding rural landscape. I arrived for the meeting in my everyday clothes, jeans, a button-down shirt, and well-worn boots, rather than the formal attire I wear in the courtroom. The receptionist directed me to a conference room where 5 people sat around a polished table, each with a tablet and a folder bearing the association logo. "Thank you for coming today," began a man who introduced himself as Richard Harlow, president of the Homeowners Association. His smile did not reach his eyes as he gestured for me to take a seat. "We appreciate the opportunity to discuss compliance matters directly with property owners." I noted immediately that he referred to me as a property owner, rather than a neighbor or community member. It was a subtle but telling distinction. As the meeting progressed, I realized Richard was not simply a dedicated volunteer, but a former real estate developer who had orchestrated the purchase of the original farmland and still maintained controlling interest in several undeveloped parcels adjacent to my property. "Let me show you what we are concerned about," Richard continued, turning his tablet toward me. The screen displayed satellite imagery of my property with red markers indicating what they termed areas of concern. The bridge was prominently marked, along with several other structures that had stood for generations. I explained calmly that there appeared to be a misunderstanding regarding property boundaries and jurisdiction. "My property is not part of your planned community," I stated, pulling out county records and the original deed that clearly showed my boundaries. "Additionally, the bridge you have marked is a protected historical structure that is registered with both the County Historical Society and state environmental protection agencies due to its location over a designated watershed." Rather than acknowledging the documentation, Richard exchanged glances with a woman he introduced as their legal counsel. "We have reviewed the original property records from when the farm was subdivided," she said, without examining my paperwork. "Our analysis indicates that an easement agreement from 1973 places your access road and bridge within community boundaries." I requested to see this alleged easement agreement, but they claimed it would need to be retrieved from storage. Instead, they shifted the conversation to what they called their community vision, a presentation that revealed plans for expansion that would envelop several surrounding properties, including significant portions of my land. As I drove home that afternoon, I realized this was not a simple misunderstanding. The meeting had been a calculated attempt to intimidate rather than resolve. Their dismissive attitude toward legal documentation and historical preservation status suggested something more concerning than bureaucratic overreach. This was a deliberate strategy. The following weeks brought an escalating series of notices, each more threatening than the last. The envelopes now contained photographs of my property taken from the public road, with circles and arrows marking alleged violations. The most concerning was a close-up image of the bridge with the notation "unsafe structure," scheduled for inspection. I responded to each notice with certified letters containing copies of the bridge's historical designation, environmental protection documentation, and property boundary surveys. I maintained professional language and cited relevant local and state statutes protecting such structures. I also installed security cameras at key points around my property, particularly monitoring the bridge and access points. During this time, I discovered I was not alone in experiencing this pressure. An elderly couple who owned 10 acres adjoining the development had received similar notices. A family who had operated a small organic farm for 3 generations was fighting citations regarding their greenhouse structures. It became clear the HOA was systematically targeting properties that bordered the development, seemingly as part of a larger acquisition strategy. One evening, I observed a group of people in association polo shirts standing at the edge of my property, photographing the bridge and gesturing toward the creek. When I approached and identified myself as the owner, their demeanor changed from confident to cautious. The man who appeared to be leading the group introduced himself as an environmental compliance officer for the association. "We have concerns about the structural integrity of that bridge and its impact on the protected waterway," he stated, though he failed to produce any credentials indicating expertise in either structural engineering or environmental science. The bridge has been inspected regularly by county officials and was reinforced according to historical preservation guidelines just 3 years ago, I informed him. All work was permitted and supervised by environmental protection agencies due to the sensitive nature of the waterway. He appeared momentarily flustered before recovering his authoritative tone. "Nevertheless, our community standards require proper certification of all structures affecting watershed areas. You will receive formal notification of required compliance measures." That night, I began organizing all documentation related to the bridge and property boundaries into a comprehensive file. Years of legal experience had taught me to prepare methodically when facing adversaries who disregarded proper procedure. I still believed this situation could be resolved through proper channels, but my professional instincts were signaling that a more significant confrontation might be inevitable. The Ninth Circuit Court of Appeals had assigned me to hear a complex interstate commerce case in Sacramento, requiring me to be away from the ranch for 9 days. I arranged for a neighbor to check on the property periodically, and left with a sense of unease that I attributed to the ongoing situation with the homeowners association. The case consumed my full attention during the day, but each evening I found myself checking the security camera feeds on my phone, reassured by the peaceful scenes of my undisturbed property. On the 7th day of the trial, my security system sent an alert indicating camera failures at multiple points on the property. I attempted to access the feeds without success. Calls to my neighbor went unanswered until late that evening when he finally responded with disturbing news. "There are construction vehicles and workers all over your back property. They say they have permits to remove dangerous structures." I immediately contacted the county sheriff's office, requesting they investigate potential trespassing, but was informed that the workers had indeed presented permits authorizing the removal of an unsafe bridge structure impacting protected waterways. The deputies had examined the paperwork and found no cause to intervene. My request for them to verify the permits with county offices was met with the explanation that administrative offices were closed until morning. I was scheduled to deliver a critical ruling the following day and could not leave without compromising the federal case before me. I spent a sleepless night making calls to local authorities and sending emails to county commissioners, all to no avail. The wheels of bureaucracy turned slowly, especially after business hours. By the time I was able to secure emergency intervention from the Historical Preservation Office, it was too late. I returned home on the 10th day and drove directly to the bridge site. What I encountered stopped me cold. The bridge was gone, not simply damaged or partially removed, completely destroyed. Splintered beams lay scattered across the creek bed. The stone foundations that had stood firm through a century of seasonal floods had been pulverized. Heavy equipment tracks cut deep into the protected banks of the waterway, and the creek itself ran brown with disturbed sediment. As I stood in stunned silence, a black SUV with the Willow Creek Estates logo on its door pulled up behind my vehicle. Richard Harlow stepped out, accompanied by two men I recognized from the HOA board and a woman carrying a clipboard. "I see you have returned from your trip," Richard stated, his tone professionally detached as if commenting on the weather. "We wanted to inform you that emergency action was required regarding the unsafe structure spanning the waterway. Our environmental compliance team identified imminent danger to the protected watershed." The woman stepped forward, extending her clipboard. "These are copies of the permits and emergency action authorization. Everything was done according to proper procedures." I took the documents with hands I forced to remain steady, though rage pulsed through me with each heartbeat. The permits appeared official at first glance: county letterhead, appropriate stamps, signatures from regulatory offices. But years on the bench had taught me to notice discrepancies. The environmental impact authorization was dated 2 days after the demolition had begun. The historical preservation waiver cited imminent structural failure as justification for emergency action, yet no structural engineer was listed as having inspected the bridge. "You falsified these documents," I stated, my voice low and controlled. Richard maintained his practiced smile. "That is a serious accusation. Our team followed all required protocols. If you have concerns about the permitting process, you are welcome to file a complaint with the county offices." "The bridge was a registered historical structure on private property," I countered. "You had no authority to enter my land or to remove the structure under any circumstances." The woman with the clipboard interjected smoothly. "Our records indicate the bridge was located within HOA jurisdiction based on the original property easements. We have documentation showing the structure posed an environmental hazard to the protected waterway. I will need copies of all work orders, contractor information, and communication regarding this action," I stated, falling back on the procedural approach that governed my professional life. "Of course," Richard replied with false cordiality. "We maintain transparent records of all association actions. You can submit a formal request through our administrative office. Processing typically takes 4 to 6 weeks." They departed with practiced efficiency, leaving me alone with the destruction before me. I walked carefully down the eroded bank to fully assess the damage. The creek water, normally clear enough to see the rocky bottom, was clouded with silt. Fragments of the hand-forged metal supports lay half-buried in mud. A piece of the carved handrail, the one my great-grandfather had personally crafted, protruded from the debris like a broken bone. That evening, I sat on my porch watching the sunset cast long shadows across the violated landscape. For the first time in my judicial career, I experienced what countless litigants in my courtroom had felt: the raw, personal sting of injustice. The bridge had connected more than 2 pieces of land. It had been a physical link to my family's history, to generations who had crossed those planks carrying harvests, leading livestock, or simply seeking the solitude of the meadow beyond. I took a glass of bourbon outside and methodically documented everything with my phone: the destruction, the environmental damage, the heavy equipment tracks leading from the development onto my property. As night fell, I reviewed the falsified permits under the harsh light of my desk lamp, making detailed notes of each discrepancy, each procedural violation, each fraudulent claim. Sleep evaded me that night. Instead, a cold clarity emerged, a familiar sensation I had experienced before difficult cases. This was no longer about a bridge. It was about accountability, about standing against those who believed power and procedure could shield them from consequences. Tomorrow, I would begin building something new, a case that would make them wish they had never set foot on my land. The morning after discovering the bridge destruction, I did not allow myself the luxury of continued anger. Emotion clouds judgment, and clear judgment was now my most valuable asset. I dressed in the suit I reserved for the most significant federal cases, a subtle armor that helped shift my mindset from victimized property owner to methodical legal strategist. My dining room was transformed into a command center, walls soon covered with satellite maps, property surveys, and a detailed timeline of events. My first call was to Samuel Winters, a former clerk from my early judicial days who had become one of the state's leading environmental attorneys. I provided only the essential facts without revealing my strategy. I need a comprehensive environmental impact assessment of creek damage resulting from unauthorized demolition activity. Priority status, full documentation, water quality testing, sediment analysis, and projected restoration requirements. Samuel asked no unnecessary questions. I will have a team on site this afternoon. Do you want this handled through official channels or privately for now? Begin privately, I instructed, but prepare everything to evidentiary standards. This will eventually involve multiple regulatory agencies. My next call was to the State Historical Preservation Office. I had previously worked with their director on a case involving protected landmarks on federal land. She expressed immediate concern about the destruction of a registered historical structure. "This is unprecedented," she stated after I described the situation. "A registered structure cannot be demolished without extensive review, even under emergency circumstances. I am sending our senior preservation officer and documentation specialist today. We need to establish the bridge's condition prior to destruction and catalog all salvageable historical elements." I systematically contacted every relevant authority: the County Environmental Protection Office, the State Water Quality Board, the District Attorney's Office for the county. With each call, I identified myself simply as the property owner, not as a federal judge. I wanted their unfiltered responses, their standard operating procedures, not the heightened attention my title might generate. By mid-afternoon, professionals from various agencies began arriving at the property. They moved methodically around the creek bed, collecting water samples, photographing the damage, measuring the erosion to the protected banks. The historical preservation team documented each piece of the bridge they could locate, creating a detailed catalog of the destroyed structure. Between coordinating these assessments, I conducted research into the Willow Creek Estates Homeowners Association. Their public filings revealed a pattern that extended beyond my property. Over the past 3 years, they had systematically expanded their boundaries through what they termed historical easement enforcement. 6 smaller properties had been incorporated into the development after sustained pressure from the association. In each case, the pattern was similar: allegations of violations, escalating fines, and eventually, property owners selling to the development corporation directly linked to Richard Harlow. Most concerning was what I discovered about their permitting history. 3 separate complaints had been filed with county offices regarding questionable permits presented by association representatives. In each case, the complaints had been dismissed due to insufficient evidence or administrative oversight. The consistency suggested not coincidence but strategy. As evening approached, an unexpected visitor arrived. Margaret Chen, an elderly woman I recognized as the owner of the organic farm adjacent to my property, walked slowly up my driveway, leaning on a handcrafted walking stick. "I saw the vehicles," she said without preamble. "They did it to you too." I invited her inside, where she placed a folder on my dining table. "2 years of harassment," she explained, opening the folder to reveal dozens of HOA notices similar to those I had received. "They destroyed my irrigation system last spring, claimed it was diverting water illegally. Fourth-generation farm, and suddenly my water use is illegal." Before she departed, 3 more neighbors had arrived, each with similar stories and documentation. Tom Fletcher, whose private road had been barricaded by the HOA. The Sanduvals, whose historical barn had been condemned through suspicious inspection reports. Elizabeth Reed, a retired attorney whose solar panel installation had been dismantled during her hospital stay. "They target properties strategically," Elizabeth explained, her finger tracing boundaries on my property map. "Each acquisition creates access to the next target. Your land connects several parcels they already control." By nightfall, my dining room table was covered with evidence of a systematic campaign of property acquisition through regulatory harassment. I organized everything methodically, creating individual files for each affected property owner and cross-referencing them with HOA board meeting minutes obtained from public records. That night, I received a call from Samuel Winters. "The preliminary environmental assessment is worse than expected," he reported. "The creek damage extends beyond your property lines. They disrupted spawning grounds for a protected fish species. That elevates this to potential federal violations." I thanked him for the information without revealing my thoughts. Each piece of evidence was forming a mosaic that extended far beyond a destroyed bridge. The HOA had not simply targeted my property. They had established a pattern of systematic abuse of process and environmental disregard that potentially violated multiple federal statutes. Before retiring for the night, I drafted a carefully worded letter to the Homeowners Association. Unlike my previous communications, this one requested specific documentation: meeting minutes authorizing the bridge removal, copies of all permits and applications, contractor credentials, and environmental impact studies conducted prior to demolition. The letter was intentionally detailed and procedural, giving no indication of the comprehensive case I was building. Let them continue believing they were dealing with a frustrated property owner who could be intimidated through bureaucratic maneuvering. Their continued underestimation would be their undoing. The comprehensive evidence gathering continued for 2 weeks. During this time, I maintained my judicial duties while dedicating every evening and weekend to building what had evolved from a simple property dispute into a multifaceted legal case. My professional background provided the framework for a strategy designed not merely for compensation, but for complete accountability. The environmental assessment had been completed, producing a 47-page report documenting extensive damage to the protected waterway. Water quality samples revealed elevated levels of contaminants from equipment hydraulic fluid that had leaked during the bridge demolition. The disruption to the creek bed had destroyed spawning grounds for 2 protected fish species, violations of both state environmental regulations and federal clean water statutes. The Historical Preservation Office provided equally damning documentation. Their report concluded that the bridge had been in excellent structural condition, directly contradicting the HOA's claims of imminent failure. More significantly, they discovered that the historical designation had been temporarily removed from county records through an administrative process typically reserved for structures damaged beyond repair in natural disasters. This manipulation of records had occurred 3 days before the demolition, strongly suggesting coordinated deception. Most damaging was the forensic documentation analysis completed by a specialist from the State Attorney General's office. The permits presented by the HOA contained multiple irregularities, inconsistent font usage in official forms, signature stamps rather than original signatures, and most conclusively, approval dates that were impossible given the processing protocols of the issuing offices. I arranged a conference call with 7 attorneys specializing in different aspects of the case: environmental law, property rights, historical preservation, administrative procedure, permit fraud, civil rights violations, and federal regulatory enforcement. Without revealing my identity, I presented the evidence as a consultant for the affected property owner. "We are not pursuing simple damages," I explained as we discussed strategy. "This case represents systematic abuse of process, falsification of government documents, environmental violations with potential criminal liability, and a pattern of targeted harassment that may constitute racketeering under federal statutes." The environmental attorney whistled softly. With this evidence package, we could file under at least 3 federal Environmental Protection Acts. The creek contamination alone supports significant civil penalties. The historical preservation violations provide another avenue, added another specialist. Intentional destruction of a registered historical structure through falsified documentation constitutes multiple felony violations. We constructed a multi-layered legal strategy. Rather than a single comprehensive lawsuit that might be delayed through procedural challenges, we would initiate parallel actions at different levels of government. Each filing would target specific violations, creating a legal net too complex to untangle through standard defensive measures. "The key is sequencing," I noted. "We begin with the environmental and historical preservation violations through regulatory channels. Once those investigations are formalized, we proceed with civil actions against both the HOA as an entity and board members as individuals. The criminal referrals for document falsification come last, after we have established the pattern through civil proceedings." By the 3rd week, my documentation had grown to fill 3 large binders, each representing different aspects of the case. The first contained all evidence related to the bridge destruction and property rights violations. The second held the environmental and historical preservation documentation. The third detailed the pattern of similar actions against neighboring properties, establishing the systematic nature of the HOA's tactics. It was time for the first subtle indication to the HOA that they had miscalculated. I drafted a formal letter on plain stationery, requesting specific documentation related to their actions. Unlike my previous communications, this one included precise citations to federal statutes regarding document preservation and spoliation penalties. The language was technically precise, using legal terminology that would be familiar to attorneys but might not immediately alert the HOA board to my background. 2 days later, I received a phone call from Richard Harlow. His tone remained confident, though slightly more formal than in our previous interactions. "We received your letter requesting quite extensive documentation," he began. "While we appreciate your concerns, The association is not obligated to provide internal records to non-members. As we have previously explained, your property falls within our jurisdiction through historical easements, but you have repeatedly refused to acknowledge member status. I allowed a measured pause before responding. I believe you will find that my request falls under federal document preservation requirements rather than member information rights. The specific statutes cited create an obligation independent of membership status. Another pause, slightly longer this time. Our legal counsel will review your request and respond appropriately. In the meantime, I should inform you that the board has approved implementation of daily noncompliance fines regarding several ongoing violations on your property. Please ensure those violation notices are properly documented and delivered through certified mail, I replied evenly. And Mr. Harlow, I would suggest your counsel pay particular attention to 18 U.S.C. Section 1519 regarding destruction or falsification of records in federal investigations. Good day. I ended the call, knowing the mention of a specific federal criminal statute would prompt at least some concern. The first pebble had been cast into the pond. The ripples would soon begin to spread. The first court hearing was scheduled for a Monday morning in federal district court. I had arranged for judicial coverage of my own caseload, explaining to the chief judge that I was involved in a personal legal matter requiring my full attention. I dressed conservatively in a charcoal suit rather than my judicial robes, taking a seat at the plaintiff's table alongside Samuel Winters, who would present the initial arguments. Richard Harlow and 3 HOA board members entered the courtroom with confident strides, accompanied by 2 attorneys from a prestigious regional firm. They took their places at the defense table without glancing in my direction. Their body language suggested routine procedure rather than serious concern, shoulders relaxed, casual whispers exchanged, the comfortable demeanor of those accustomed to navigating minor legal inconveniences through superior resources. The bailiff called the court to order, and Judge Elena Rodriguez entered. She was a former colleague with a reputation for meticulous attention to procedural detail. I had specifically requested her for this initial hearing, knowing her background in environmental regulatory enforcement would be valuable given the nature of the case. Counsel, please state your appearances for the record, Judge Rodriguez instructed. Samuel stood. Samuel Winters appearing for the plaintiff, Your Honor. The lead defense attorney rose next. Jonathan Preston and Maria Vasquez appearing for Willow Creek Estates Homeowners Association and its named board members, Your Honor. Judge Rodriguez nodded, then glanced down at her papers. Before we proceed with initial arguments, I note that the plaintiff is present in the courtroom. For the record, please state your name. I stood straightening my suit jacket. The Honorable Judge Alexander Marshall, United States Federal Court, Northern District, Your Honor. The effect was immediate and profound. Richard Harlow's head snapped up, his practiced composure fracturing visibly. The defense attorneys exchanged alarmed glances, papers rustling as they hurriedly consulted notes. One board member leaned forward to whisper urgently to counsel, his expression betraying sudden apprehension. Judge Rodriguez maintained her professional demeanor, though the slightest arch of her eyebrow acknowledged the unusual circumstance of a federal judge appearing as a plaintiff. The court recognizes Judge Marshall. Please be seated. Samuel Winters presented our opening statement with devastating precision, laying out not merely the destruction of the bridge, but the comprehensive pattern of manufactured violations, falsified documents, and environmental damage. He methodically introduced evidence packages to the court, each one addressing specific aspects of the HOA's actions. Your Honor, we are prepared to demonstrate that the defendants engaged in a systematic campaign targeting multiple properties through fraudulent use of regulatory processes. The destruction of a federally protected historical structure was not an isolated incident, but part of a deliberate strategy to pressure property owners into relinquishing valuable land holdings. The defense attorney appeared increasingly concerned as the presentation continued. When his turn came to respond, his argument focused narrowly on jurisdictional challenges rather than addressing the substance of the allegations. Your Honor, while we respect the plaintiff's position as a member of the federal judiciary, this matter fundamentally concerns local property boundaries and homeowner association bylaws. We contend that federal court is not the appropriate venue for what is essentially a neighborhood dispute. Judge Rodriguez reviewed the evidence packages before responding. Counsel, the complaint before me includes allegations of Clean Water Act violations, destruction of federally protected historical structures, and systematic falsification of government documents. Each of these elements falls squarely within federal jurisdiction. Your objection is overruled. As the hearing progressed, I observed Richard Harlow's demeanor transform from confident to concerned to visibly anxious. When Judge Rodriguez asked if the defendants wished to make a statement regarding the environmental damage documented in the assessment report, he conferred urgently with counsel before declining to comment. The most damaging moment came when Samuel presented the forensic analysis of the permits used to authorize the bridge demolition. The document examiner testified to specific evidence of falsification, including digital manipulation of official signatures and backdated approval stamps. Judge Rodriguez examined these exhibits with particular attention, her expression remaining neutral though her questions grew increasingly pointed. By the time the initial hearing concluded, Judge Rodriguez had issued temporary injunctions preventing the HOA from taking any further actions regarding my property or those of the other affected neighbors who had joined the case. Additionally, she ordered preservation of all association records and communications related to permitting, property boundaries, and enforcement actions. Outside the courthouse, reporters from local media had gathered, alerted to the unusual case of a federal judge suing a homeowners association. I declined to comment specifically on the proceedings, but made one brief statement. This case is fundamentally about the rule of law applying equally to everyone. No organization, regardless of its size or influence, has the authority to falsify government documents, destroy protected environmental resources, or violate property rights through manufactured bureaucratic processes. That evening, I received the first settlement offer from the HOA's attorneys. The proposal included financial compensation for the bridge destruction, reversal of all claimed violations against my property, and a confidentiality agreement regarding the proceedings. I declined without counteroffer, directing Samuel to inform opposing counsel that we would proceed with the full case as filed. The following day, the State Environmental Protection Agency announced a formal investigation into the creek contamination, citing potential criminal violations. By week's end, 2 HOA board members had resigned their positions, and local media had begun investigating similar complaints from other communities where Richard Harlow had development interests. The case had transcended my personal property dispute. It had become a referendum on accountability for those who believed procedures, paperwork, and positions of authority placed them beyond the reach of consequences. 6 months of legal proceedings revealed a pattern more extensive than even I had initially suspected. Discovery produced internal HOA emails explicitly discussing strategies to target properties for acquisition through regulatory harassment. Board meeting minutes documented deliberate decisions to pursue aggressive enforcement against specific properties considered strategically valuable for future development. Most damning were communications between Richard Harlow and county officials, showing inappropriate influence over permitting processes. The final judgment came on a crisp autumn morning. Judge Rodriguez entered the courtroom, her expression solemn as she took her seat at the bench. The gallery was filled with affected property owners, environmental advocates, historical preservation specialists, and members of the media. Richard Harlow sat at the defense table with significantly different counsel than when the case began. His prestigious firm had withdrawn representation mid-proceedings, replaced by a sole practitioner specializing in damage control. This court has carefully considered all evidence presented in this matter, Judge Rodriguez began. The actions taken by Willow Creek Estates Homeowners Association and its leadership represent a fundamental disregard for environmental protections, historical preservation statutes, and the property rights of community members. The systematic nature of these violations reflects not isolated mistakes, but calculated strategies to circumvent regulatory safeguards for personal gain. Her ruling was comprehensive and unequivocal. The HOA was assessed $2.3 million in damages for the destruction of the bridge, environmental remediation requirements, and civil penalties for document falsification. Richard Harlow and 3 board members were held personally liable for actions taken outside the scope of their official duties, particularly regarding the falsified permits and unauthorized entry onto protected properties. Beyond monetary penalties, the judgment included structural reforms to prevent similar abuses in the future. The HOA charter was placed under court supervision for 5 years, with an independent monitor appointed to review all enforcement actions. Property boundaries were permanently established according to original deeds, with explicit prohibition against claiming jurisdiction through disputed easements. Most significantly, the development corporation controlled by Richard Harlow was barred from acquiring any additional properties in the county for a period of 10 years. The environmental remediation began the following spring. Specialists in stream restoration worked carefully to rebuild the creek bed according to its natural contours, replanting native vegetation along the banks and reintroducing the protected fish species whose habitat had been destroyed. The water gradually cleared, once again revealing the rocky bottom that generations of my family had waded through during summer months. The bridge reconstruction commenced under the supervision of historical preservation experts. Using photographs, measurements, and surviving elements of the original structure, craftsmen recreated the distinctive design that had stood for nearly a century. Where possible, salvaged materials from the destroyed bridge were incorporated into the new structure. The hand-forged metal supports were replicated by a blacksmith using traditional techniques, and the distinctive handrail was carefully reconstructed from the same species of oak used by my great-grandfather. Throughout the restoration process, neighbors who had faced similar pressures from the HOA often gathered at the construction site, sharing stories of their own experiences and watching with satisfaction as each beam was set in place. What had begun as an individual property dispute had transformed into a community, reclaiming its identity from those who had attempted to reshape it through intimidation and procedural manipulation. On the day the bridge was completed, I hosted an informal gathering for neighbors, environmental advocates, and the craftsmen who had worked on the restoration. We stood together on the new planking, which creaked pleasantly underfoot just as the original had done. A small bronze plaque had been mounted at the entrance, reading simply, "Preserved by law, rebuilt by community." As evening approached and visitors departed, I remained on the bridge alone, watching the restored creek flow beneath. The legal victory had never been about financial compensation or personal vindication. It represented something more fundamental, the principle that rules and procedures exist to protect rather than exploit, that document filings and board meetings cannot shield deliberate wrongdoing, that even the most powerful must ultimately answer to the law. In my years on the federal bench, I had presided over cases involving multinational corporations, international treaties, and constitutional challenges. Yet this battle, fought with property deeds and water quality reports rather than precedent-setting opinions, had perhaps been the most important of my career. It served as a reminder that justice matters not only in landmark courthouses, but in the quiet struggles of ordinary people facing those who believe power places them beyond accountability. Standing on the rebuilt bridge as sunset painted the water below with golden light, I understood that my greatest contribution as a judge might not be found in published opinions or legal precedents, but in this simple, wooden structure connecting one piece of land to another. It stood now as testament that no association, no board, no organization is above the law, and that protecting what matters requires not just knowledge of legal statutes, but the courage to enforce them when they are most threatened. The creek continues to flow beneath this bridge as it has for generations before me and will for generations after. But now its path carries an additional legacy, a reminder that sometimes justice requires not just a gavel, but the determined resistance of those who recognize when power has overstepped its bounds. In the face of those who would bulldoze history for profit, the greatest weapon remains the simple, unwavering insistence that the law protects us all equally, from the smallest homeowner to the most powerful developer.